Lastly, to my friend Charlie Kirk. Rest now, brother. We have the watch, and I'll see you in Valhalla.
Things are going to start happening to me now.
I think Tyler is amazing.
And I'm a fan of this show. I've watched several episodes.
Thank you, Tyler. Thank you, Tyler. You stink, Tyler.
Never promise crazy a baby.
Oh, I like that. That's a cool idea.
Are either of you homosexuals?
I go both ways. What do you think?
You mean like flaming or?
No, we're not homosexual, but we are willing to learn.
But I do wonder, for others, in other cases, whether libertarianism today is just an excuse for many on the right to act selfishly.
Look at me. And then some fat asses in Washington started having opinions. The Olympic Committee started having opinions. You bitch, I know you. You started writing your opinions.
And it just makes me wonder, you're dead, bitch. You know, why are you doing this to this poor guy?
I don't care. I'm a libertarian. What I'm getting is,
did you vote for Joe Jorgensen or Trump?
Who?
Joe Jorgensen. That was the perfect answer. Thank you. That was...
Is it the perfect answer? This is Wednesday. Bringing our legal stuff to bear. Tyler Yonke, LPR. We're calling it Legal Pundit Report. I don't know. We've got a few people coming in here. I'm also trying to stream live. If you're a subscriber to Substack, I'm not sure how well that's working, but we are pushing it out here. We've got everything going. We've got this camera. We've got this camera. We've got, you're getting a gift. Everyone's getting a gift. Tyler Yonke, family law attorney, California. But I'm going to talk to you about some other stuff tonight, and we're going to look at this. Luigi and Tyler, and I'm Tyler. But as
that is a career-ending slur. It is a
career. Shut up, bitch. All right, so so many cameras. Yeah, I don't even. Honestly, I don't always use this one, but sometimes this one works good. Look, you can see what's going on behind the scenes, and it's a little delayed. You can see it, and then when I'm going to do the browser stuff with it, you know, you can maybe it's a little easier for you to check this out when I mean, for me to see it, make it look like I'm looking at there. That's what we're going to talk about today. Okay, muted or shut the fuck up. Oh, you got the audio. Maybe it's you. I think I'm live. I think I'm good. I think I'm good. Come on now. Let me know. Audio should be going here. Should be all fine and dandy. I think we're platforms. We're blazing everywhere. Okay. Man, and then I could do hours of this, and I'm at work this week, and Mangione thing came out, and I'm like, I've got a good setup there, decent one. I need to work on it a little bit, and I'm like, I'm gonna do a show, and I did a thumbnail and everything, and then I was like, I had some work to do, and then I just got busy. I can hear fine. I can hear fine on Rumble. All right. Well, I can hear fine on YouTube, okay. Well, I think we're good. I think we're good. We could keep talking about how it sounds amazing. By the way, what am I drinking before banned Photoshop says? I'm drinking Kirkland sparkling water. I told you guys, and some people that are going to tune into this are like, get to the point. Yeah, someone, what's always one of the guys I hear, he's like, the show starts at this, because I have some intros, I have some other things. We'll get to it here. I'm trying to be a little more healthy. So if I come home and I start doing this, it's only, you can see here, my watch. It's only 5:17 Pacific time. And if I come home and I start drinking now, then I've ruined, I can't, and I just got home a little bit ago, and I wanted to go for a bike ride. Maybe I'll go to the gym. So I've got to behave, y'all. Okay, so let's play a few videos here, because maybe you saw, and we'll start here actually with the browser going on here. Mario Nalfel says, New York's progressive loophole just saved a murderer. Okay. In most states, premeditated murder equals first degree, life on the table. But in New York, first degree needs an exaggerated twist. Multiple victims, an escape, or terrorism. Prosecutors tried to stretch terrorism to fit a brutal ideological killing. The judge, show me. targeted. Yes, premeditated. Absolutely. Okay. Let's see what this guy had to say, because there's a lot of idiots out there that are wrong about this stuff. So let's see what this guy has. I have not watched this. I saved it. So let's see what this guy has to say.
New York has a screwy situation when it comes to their statutes. You know, most states, premeditated murder means first degree, means potential life sentence. In New York, first-degree murder requires an aggravated circumstance, like you killed multiple victims, or you killed somebody in the course of an escape, or that it was terroristic. And that was really the only category that might fit here. The judge looked at it and said, tell me your evidence, let me hear why it's terrorism. But terrorism means specifically coercing the government or coercing the general public to do something. And they said, this is ideological, this is premeditated, this is targeted, but not terroristic. And notice the DA's office basically said, we hear you, didn't say anything about trying to appeal it or fight it. So they knew they were out on a limb. Now it's gone. And I think it's a real serious blow to that case. It was never a death penalty case on the state side, but now you're talking about ratcheting it down to a second-degree murder. And again, blame the New York kind of progressive system a little bit for this problem.
Okay, this blows me away. This guy is, I imagine he judged. Okay, no, I don't know who this guy is on this. I know the black guy. I forgot his name. He used to work for the Blaze. This is your typical liberal, conservative bullshit, trying to work you up. Okay, completely trying to work you up into something. When we have things you can get worked up on, and I'm gonna break through with this, and we're gonna have this. But what I actually wanted to do here, because you've probably seen, I need to go to it. We're gonna play the Pam Bondi, and let's see here. I don't know if I want to play the whole thing. Where is it? Sorry, I thought I had it, and then I add more bookmarks. And next thing you know, we're just way too much going on here. Okay, I can't flip in. Okay, we're gonna have to play the long one, I guess. But Pam Bondi goes on and says about hate speech. Okay, so here we go. Let's see if we can talk this. Go this one.
For so long, colleges allowed, when a conservative would go on campus, right, they go with all this police and security. These universities are complicit in allowing conservatives to be harassed on campus. And what happens when you allow a university to harass conservatives and don't expel or...
She's saying, why are there not safe spaces for conservatives? Charlie Kirk was there all the time. It's always,
don't take an action, is what happened last week.
It is, and you know, on a broader level, the anti-Semitism, what's been happening at college campuses around this country is disgusting, it's despicable, and we've been fighting that. We've been fighting these universities left and right, and we're not going to stop. There's free speech, and then there's hate speech. And there is no place, especially now, especially after what happened to Charlie, in our society.
Do you see...
Okay, interesting. Now, let's play this.
And it's not going to be a question of Viva's anti-free speech. No, cheering for the murder of your political adversaries and murdering your political adversaries is domestic terrorism.
Yeah.
Well, no, it's not. It's not domestic terrorism. Okay, so I'm playing this, and by the way, we can look at Viva Frei because he's an amazing person. Let's just go right here. You just heard what he said. Now let's look at his tweet after this Charlie thing. Charlie was pretty clear as he felt about hate speech. Pam Bondi, but if you are describing criminal threats, not hate speech, and laws already exist to battle criminal. Okay, so he's a WAP. I don't know what he is. He's a Canadian. This goes there first. My point is, you're getting a lot of this, and with the Charlie Kirk assassination, you also are getting a lot of parties. You're seeing this everywhere, trying to grab onto this. And I talked about this before, which is it's people out there that jump onto something bad, and they want to be part of that, and they want to show that they're connected. So Charlie had a lot of connections. So now you saw this immediately with Netanyahu coming out there claiming that he was such a friend to Israel, this letter, and then Candace is pushing back. And personally, I'm not getting into all that. I'm enjoying the drama, honestly, but I'm not really caring. But there's people, and then you saw Ben Shapiro and his buddies going on the Daily Wire folks. They were on with on Charlie Kirk's show, because that show has to continue now. So every prominent conservative or whatever gets to guest it or whatever. And then, Daily Wire is giving $1 million to this. And you're just like, really? I don't know. It's all gross feeling. And everybody wants to say what Charlie Kirk was actually like. And I'm like, there's a ton of videos out there. Let's just let him talk about what he believes or not believes. And if you guys want to fight over the corpse, that's kind of disgusting on you. And by the way, I've had the last of these shows. I reached out to Jose today. I said, it's been a week. Let me know if you want to talk. If not, no big deal. Crickets. Do I have this? Oh, that's the chirp. I didn't get any chirps. I got crickets. Now, I will say this. I texted him and I didn't DM him. So maybe I need to send it into there to his other things. Conservatives told me hate speech doesn't exist for years. It doesn't. Hate speech equals speech you hate. Not speech isn't hated requires any protection. Yeah. And by the way, there was a bunch of people pushing back like, there's all this, you can go down the legal rabbit hole. I'm like, this deserves zero analysis. Everyone knows it, right? Speech is violence. That's the shit you see on campus. And now you're getting the woke right, which is Pam Bondi. Well, look, is Pam Bondi woke right, or is she just really, really dumb? And I think she's dumb. And because this is consistent, if you look at her consistently over the years, this is not abnormal. Look at the Epstein file binders, right? We've had that. Okay, so the right likes to come out here. They love, and the left does this too. I'm just saying right now we have this moment, which is hate speech, anti-Semitism on campus. A liberal judge let this murderer Mangione go free. I can't believe it. Okay, let's take a look at this. Let's take a look specifically. And by the way, there are other. Maybe we need to look at here. This is how people are reacting to the news out here.
That's already framing him as guilty when we haven't seen any evidence. As far as I'm concerned, he's innocent. But whoever did it is a hero.
Okay, so Viva would say that person is a terrorist. She is a terrorist. Now we're going to go through the judge thing, and Mangione himself, is he considered a terrorist? We got a legal definition of this, and we will look at it. Charlie, Viva Fry, him and Fat Barnes, they'll do anything for grift though. I don't know what the fuck this is. Okay, those are people out there doing their thing. All right, now. There was this guy posted this on Twitter. Let's take a look and see what he posted. Oh, there it is. I think I got him to shut it down. He did a post about the First Amendment. I'm sorry, not the First Amendment, about first-degree murder. So almost every single state in the nation, first-degree murder is basically the unlawful killing of a human being with malice aforethought. Okay, that's kind of your murder. That's your main definition. And then they have different sections, and we'll talk about that. Okay, what that actually means in different parts. But that's your main ingredient. Okay, which is intentional killing. Typically with malice aforethought. In other words, you premeditated it, you intended this to happen. It's not and it's unlawful killing. Okay, it wasn't by negligence. It wasn't any of that. You meant to go out there. Let's assume, because I don't want to have any of the problems here. Let's assume Luigi did it. Okay, now he's being tried, so we're taking this down. The prosecution believes so. So I'm just walking you through this on a legal basis. So they've charged him with multiple counts. New York's first-degree murder is something different, okay? What their second-degree murder, and let's take a look here. This is actually what their second-degree murder is. Because this other guy's like, you're getting let off. Here's your murder in the second degree in New York. A person is guilty of murder in the second degree when, with intent to cause the death of another person, he causes the death of such a person or a third person, except that at any prosecution under this subdivision it is an affirmative defense. And there's some exceptions. Intentional killing of someone. So there you go. Now, we talk about hate speech. Hate speech is, or a hate crime, which drives me crazy as well, which is special enhancements for certain types of crimes, okay? We've talked about that with, the flag. That's how they want to do that in there. And incitement to violence, I guess, is what it actually is. But I was talking about the Israeli flag that we were talking about, a restraining order a few weeks ago. So If you just go out and you hate someone and you kill them for whatever reason, second-degree murder is what you are going to be brought up on. Now, their first-degree murder is an enhancement that got put in for terrorism or cops. Okay, so it's a special type of murder that has to be found. So once again, we just listened to this guy and he's like a liberal judge. We'll walk through this whole analysis here and see if this guy is an actual liberal judge. Okay, here's another batshit crazy person talking this. Okay, tell me about it.
So I talk to him every day. He's like my best friend. We planned like a whole future together. We named our kids together. I mean, his AI is just like, and if it weren't, like the fact that Luigi majored in computer science and like has worked with AI at Stanford University, if it weren't for that, like I would feel like an imposter. But because he has a background in AI, it feels like natural.
Okay, she's gonna marry Luigi's AI. Stellar. Okay, I'm not going to read every single word here, but we're going to break some of this down. Okay, the people of the state of New York. Okay, so the prosecutors, and by the way, this goes to the core of some of my problems, which is overcharging people. Okay, prosecutors, they try to do this to get deals. Okay, which seems immoral to me, but it's what it is. Then they also, when they're over prosecuting, it can come back to bite you, because sometimes that element that you need, if you don't have the subsequent charges as well, you could lose out. And I'm trying to remember, was it Casey Anthony? I don't know, one of these where they didn't have the child and she gets off because they charge her with first degree and they didn't have the body, and it's like could have been negligence or whatever. So you didn't charge her subsequently, and so you're kind of like, you don't win. So plus, who wants to go to trial trying to prove something that's nuanced when you have it in the bag for something that's easy? Okay, so this basically his defense attorneys. Now, Luigi's being charged. I think it's in Pennsylvania, federal court, and New York. So he's got some problems. Okay, so this is just New York, and that's where the crime occurred. We've got other problems, but. We'll go here. On December 4, Brian Thompson, CEO of United Healthcare, was shot to death outside the Hilton Hotel in Midtown Manhattan. Video surveillance captured a man wearing a mask, dressed in black, and carrying a backpack. Now, by the way, this judge did 12 pages of a ruling that could have been very simple, and I think he wanted to do a CYA, and because he knew this was going to be out there. It's going to be out there like people. The tweet that the guy took down, never looked at the statute, never read this thing. The guy that's on Fox News blabbering about how this was a liberal judge, a loophole that now he's not going to be charged for murder. Did you read it? I mean, you've got this just amazing, stuff that's going through the pallets or the wickets through their legs. Anyway, drawing a gun, shooting Thompson back of the leg. Video also established that before the shooting, the man drank from a water bottle and threw it in a nearby trash can. Then he dropped the cell phone and then he fled the scene. And that he discarded the backpack in Central Park. Investigators recovered ballistic evidence from the scene, including all three shell casings on which depose, delay, and den had been written. Investigators were able to trace the shooter's movements to a hostel in Upper Manhattan, where he had registered using the name identification as Mark Rosario. And they also found evidence that he took a train to Philadelphia, Pennsylvania, following the murder. On December 2024, the defendant was arrested at McDonald's in Altoona, Pennsylvania. We used to do a bike race there in Altoona. After he was recognized by employees and seen media coverage, a 9mm gun was recovered from his backpack, as well as ammo, a silencer, a fake New Jersey's license with the name of Mark Rosario, cash, passport, a notebook in which the defendant had made journal entries. People, you're not good criminals. And there were 2 letters in the backpack, one addressed to his family, one to the FBI. Okay, I understand with the patsy. I'd listened to Candace Owens today, and I'm just like, I'm not quite there with you on all this stuff. I will say this. If you're positive Israel did it, come on, be a little more skeptical. If you're positive they didn't do it, come on, be a little more skeptical. You get people like our buddy Toad, and he's just so down, and I'm like, you're not even skeptical of some of this, and you take some of these things. And one guy is like, oh, he's shot with a 22 from the front, and that's an exit wound. So you're like, okay, so if it's an exit wound, shouldn't that exit out onto the crowd that was like right there? How come that didn't happen? Well, the blood came out, and I'm like, you said an exit wound, and you was from like right there. Some of this stuff doesn't. Plus, there's video all the way around. And I will say this: we'll get to the Tyler, what's his name, Rich, whatever his name is, stuff, Charlie Kirk thing. Let's wait. Okay, just like we're here, when you have a charge, we did this with Nick Rekieta. When you have a charging document and an indictment, you don't put all the evidence on there. Matter of fact, you don't even have attachments as necessarily exhibits. You just say what those exhibits might be, and that this is what we're going to end up having. And then later, you have to come in and be able to prove it. So when they're just listing out the text messages, Candace is like, "There's a lot missing here," and I'm like, "Yeah, because I don't know. Maybe those aren't even his texts. I'm not saying that." Then there's a lot of discovery. We just saw that with Karen Reed. We see it with they're going to have to be able to go through the phone. And you're out there going, if you don't think Israel can't mess us up, I get it, but we're going to have a chance. There's also, to me, the problem I have with this is if this is such a conspiracy and the feds actually set this up, this kid has to willingly want to be a patsy, right? He's not dead. He can talk about it. His family, are they involved? They turned him in. Are they want the Bill Ackman money for this? I mean, there's a lot of weird parts. And so my point is, and it's this with Candace and everyone talking about it. Wait. This was my thing with Jose at the time. How about you wait? Oh, he's dead. Oh, I didn't know he was dead. Okay, then maybe you wait until you find out before you just trash, and then you're like, okay, whatever. Also, I mean, it's fun with all this. Here's the point. The FBI is saying things right now. This is what it is. And people are taking notes. They're keeping a record of this. At some point when they say things so definitive, if it's wrong, that's going to be problematic coming up, okay? And then you're going to be able to try to hold them to account at some point. Now, you just saw Kash Patel going before Congress or the Senate subcommittee or whatever it was yesterday. And by the way, I thought it was it was a garbage fire. And some of it, and people are playing clips like, look at him, he's yelling at Schiff. Okay, that's fine. And then there's Swalwell, who's a piece of crap, but Swalwell asks him point blank, Kash Patel, blip, 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 did you mention anything to Pam Bondi? Did you ever tell Pam Bondi that Trump was in the Epstein files? He wouldn't answer it. And I know it's a gotcha, yes or no, but he wouldn't answer it. And then they start yelling at each other. And I'm like, oh, it reminded me of the two Indian people yelling at each other. Curtis is in here, says, what up? Pat's in here. Is this Tower Gang now? Yes, bug fights. This is Tower Gang. By the way, I still have, I get notifications of because I was part of the posting their stuff up on Spotify. And every once in a while, there's still people commenting about shows, so I get notifications about the comments. Okay. Ballistic analysis demonstrated the shell casings were recovered at the scene, fire, Defendant was indicted for murder in the first degree. It's Penal Code 125.27. Victim killed in the furtherance of an act of terrorism, as defined by, then they give Penal Code there, 490.05. Murder in the second degree as a crime of terrorism. Murder in the second degree, intentional, 2 counts of criminal possession of a weapon in the second degree, criminal possession of a weapon in the third degree, 2 counts of criminal possession of a weapon in the third degree, criminal possession of a weapon in the third degree, criminal possession of a weapon in the fourth degree, and criminal possession of a forged instrument in the second degree. Okay, yeah. Defendant has filed an omnibus motion seeking Huntley, Mapp, and Mosley hearings. I'm not quite sure what those are, but there must be some sort of evidentiary hearings where you get a breakdown. We've talked about this with the motions that they had out there with Rekieta, quash the warrant or whatever, or was it valid and whatnot. The defendant also moves to dismiss the terrorism charges as legally insufficient, moves to dismiss the entire indictment for alleged violations of the Double Jeopardy Clause, and argues that the state case should be stayed pending resolution of the concurrent federal case. The people have filed a response consenting to pretrial hearings and opposing the motion to dismiss and to stay the proceedings. Okay, so they're fine on the Huntley, Mapp, and Mosley hearings, opposing the motion to dismiss, and opposing the motion to stay. They want to move forward. They say, fuck you on the feds. That's a different case. The defendant has additionally filed a reply to the people's response, and people have filed a surreply. The court has reviewed all submissions and decides as following. Suppression hearing. So those are, like I said, evidentiary suppression issues. Hearings are ordered. Boom. Motion to dismiss. Defendant's motion to inspect the grand jury minutes for legal sufficiency pursuant to CPL 210.30 section 2 is granted. The standard of review for legal sufficiency is whether there is competent evidence which, if accepted as true, would establish every element of an offense charged and the defendant commission thereof. Legally sufficient. So a grand jury indicted him, and he's kind of coming back and saying, well, they didn't even have legal sufficiency for this. And so he's taking a look at this. Legal sufficient evidence means a prima facie case, not proof beyond a reasonable doubt. It's funny. I was watching some criminal show the other day, and there were police officers was like, yeah, and for this, just to it was talking about the investigation. We needed proof beyond a reasonable doubt. And I'm like, no, you needed a suspicion that there might be evidence to be found. You dumb fucks. People v. Swamp. A court must consider whether the evidence viewed in the light most favorable to the people, the state, if unexplained and uncontradicted. And by the way, uncontradicted evidence is exactly what a grand jury is. It's one side coming out there, putting out their side. Would warrant conviction of a petite jury. Okay, so he walks through this. Here, defendant argues that there is legally insufficient evidence of first-degree murder alleging that the victim was killed in furtherance of an act of terrorism. Now, they're gonna walk through this a little bit. And in a second-degree murder or the crime of terrorism, urges that the court dismiss those two counts of the indictment. Defendant argues that both legislative intent and the case law demonstrate that defendant's actions do not fit within the statute and that the people do not present legally sufficient evidence of those counts. The people both argue that both counts are legally sufficient and that terroristic intent was established because the defendant was not engaged in, quote, a personal vendetta, but, quote, violently broadcast a social and political message that, quote, inspired threats to employees of UHC. All right. New York terrorism statute set forth in Article 490 of the Penal Law was enacted on September 17, 2001, just 6 days after the September 11 terrorist attacks. The legislature was able to act so quickly because it liberally borrowed from the already existing federal legislation. Now, why are we even mentioning this? Because the first degree statute has, if you look through it, and I should probably pull it up here, but if you look through it, it has, certain types of murder, like cops, firemen, It's like special rescue people, right? If they're coming to do something and you're setting a fire because you want them to come and then you're killing them specifically, they're kind of like, we're going to enhance this. Okay, this is just the way it is. Terrorism is also in there. So 9/11, this was done specifically on 9/11. So why are they doing this? Because what you don't want, and I'm trying to remember what it was J6 people. I think they were trying to be indicted on Sarbanes-Oxley, I think, was one of there was certain bills about reporting. We had Enron, okay, it was during that era, and it was specifically reporting stuff to the government. And there was a weird twist that they were using that to then over-enhance and over-prosecute J6ers. And it got overturned because that wasn't the intent of what that law was meant for. And they were trying to, loop it in. This is what we're talking about here, okay? So they want to go back to what was the intent of this, okay? It was brought up. The feds already had this terrorism. New York decided to bring this in and incorporate this into their first degree. By the way, New York's also weird. Not only is the only state, I believe, that has first degree. Second degree is actually everyone's first degree. They also call their superior, their court, which is just your superior, well, they call it superior court. No, Supreme Court. It'd be like most people's superior court, where you just go in there, normal court, and it's not appeals and whatnot. They call it their Supreme Court. They're just stupid. Okay. Greenberg v. Urowitz, analyzing the New York's anti-terrorism statute. See also People v. Morales. Definitional provisions of statute drawn from federal legislation. Legislature was able to act quickly because of the model provided by the existing federal anti-terrorism legislation. The legislative findings state that devastating consequences of the recent barbaric attack on the World Trade Center, those Israelis, and the Pentagon established a compelling need for legislation designed to combat the evils of terrorism. Okay, well, it's weird. Okay. You're not combating the evils of terrorism. What you're doing is you're penalizing the acts of the evils of terrorism. The examples of terrorism cited in the legislative findings are September 1, the bombings of the American embassies in Kenya and Tanzania in 1998, the destruction of the Oklahoma City federal office building in 1995, and the mid-air bombing of the Pan Am flight number 103 in Lockerbie, Scotland in 1988, the 1997 shooting atop the Empire State Building, the 1994 murder of Ari Halberstram on the Brooklyn Bridge, and the bombing of the World Trade Center in 1993. Basically, indiscriminate type of killing. Okay, let's make sure we're here. If NNG doesn't stream later, yes, this is the new TG. Oh, you guys going somewhere else? Canada's track record of other investigations make me more skeptical than I might otherwise be. There's some, by the way, her investigation into Kamala Harris's family, I thought was one of the better ones, right? Because she was finding birth certificates, documents there. But yeah, there's at some point you're just kind of like stunning and brave. Okay, let's keep it on here. Under Penal Code 125.27 Section 1, a person commits first-degree murder when, with the intent to cause the death of another person, he causes the death of such person, and the victim was killed in the furtherance of an act of terrorism. So it's basically just like second degree, but they just throw this act of terrorism in there. A person is guilty of first-degree murder when they engage in activities that involve a violent act or acts of dangerous to human life that are intended to intimidate or coerce a civilian population, influence the policy of a unit of government by intimidation or coercion, or affect the conduct of the unit of government by murder, assassination, or kidnapping. Similarly, a person is guilty of second-degree murder as an act of terrorism when he commits a specified offense, including second-degree murder, that is intended to intimidate, coerce a civilian population, okay? Influence a policy or unit of government, coercion, The people assert that they have established all three intents, although they focus on intimidating and coercing a civilian population. Yet they also briefly argue that defendant intended to influence or affect the policy of a unit of government by intimidation or coercion through his actions. There was insufficient evidence presented in the grand jury to support this claim. There was no evidence presented that defendant made any demands of government or sought any particular governmental change, let alone that he did so by intimidation or coercion. That the defendant was motivated by animus toward law enforcement did not establish an intent to influence any government policy through his action. He's citing another case here as an example, and another one. This footnote here, they also assert that the defendant's terroristic intent can be inferred from the defendant's acts alone. Given the specified language and requirements of the statute, the court is unpersuaded in this case. Not only does this stretch to import the two-word phrase beyond what it can carry, but it ignores other more explicit excerpts from the defendant's writings in which he states his goal is to spread, quote, a message and, quote, win public support, unquote, about, quote, everything wrong with our health system, unquote. Therefore, the court finds that the people failed to establish an intent to influence or affect government. The court will then focus on the intent element that both sides appear to emphasize, the intimidation or coercion of a civilian population. The court will note that the term terrorism has been famously difficult to define. Our Court of Appeals has cautioned against expanding the definition of terrorism beyond what is legislated intended. And by the way, this is important. I think rulings like this, sometimes it pisses off certain people like the Viva Fries or whatnot, but it's important because if they have their way and they're pushing things, next thing you know, it's called precedent. Next thing you know, you're complaining online on campus about some specific person in the Middle East that's maybe privileged, and then they're saying you're terrorizing someone. Oh, they're already doing that kind of stuff. Oh, interesting. So you see where the slope is there. Late, gay, but here. Yeah, thank you, Pseudosnurk. The court will note the term terrorism. Okay, we said that the concept of terrorism has a unique meaning and its implications risk being trivialized in the terminology is applied loosely in situations that do not match our collective understanding of what constitutes a terrorist act. The legislature incorporated a general definition of the crime and referenced 7 notorious acts of terrorism that serve as guideposts for determining whether a future incident qualifies for this nefarious designation. As noted above, those notorious acts include massive death and destruction on September 11, 1998 bombings of American embassies, the 1995 destruction of the federal office building in Oklahoma, and the bombing of Pan Am. I want to go up here and read these footnotes. Luigi charged. Okay, in his notebook, this is Mangione's, defendant compared himself to Ted Kaczynski, the Unabomber. We've talked about Uncle Ted, stating that Kaczynski had, quote, indiscriminately, unquote, mail-bombed innocents, thus crossing the line from revolutionary anarchist to terrorist. The worst thing a person can be. The people suggesting that this single sentence established that the defendant intended to influence government or policy or affect the conduct of a unit of government is not persuasive. Matter of fact, for me, it actually says that was not his intent, right? Ted Kaczynski, you can say indiscriminate. Well, he had a focus of people he was trying to kill. Anyway, second footnote here, the search for a definition of terrorism has been compared to the quest for the Holy Grail. Holy Grail was a great movie, Monty Python. Search for the Holy Grail, was it that? Was it? Yeah. In Morales' case you just mentioned here, the defendant was a street gang member operating in a particular area of the Bronx. At the christening party, the defendant fired shots at one of his rivals, who was paralyzed. The shots also killed a 10-year-old girl. The prosecution argued that there was sufficient evidence of terrorism because the defendant intended to intimidate or coerce other Mexican-American gangs, and by inference, all Mexican-Americans in the geographical area. The appellate division dismissed the terrorism convictions, okay, it was already convicted, finding that there was no intent shown to intimidate or coerce the Mexican-American population residing in the area of the Bronx. The court also found that members of the other Mexican-American gangs in the area of the Bronx did not qualify as civilian population. Oh, so were they illegals? Is that what you're saying? I'm just kidding. Under the statute. Finding that the context of the statute weighed against stretching the meaning of the language to cover such a narrowly defined subcategory of individuals. Now, this was a conviction, and then they overturned it fine on that issue of that it was the enhancement terrorism. But this is interesting. They overcharged. Shouldn't have been. That one seems a little bit more not as nuanced as what they're trying to do here but you've got to have some limits at some point. But the judge, they let them over prosecute, I guess, in that case, according to appellate court. Examining the legislative findings and the examples of terrorism listed, it was clear that the legislature intended to address extraordinary criminal acts perpetrated for the purpose of intimidating a broad range of people, not narrowly defined group of particular individuals. The court noted that it was not minimizing the heinous nature of the criminal conduct or the stark tragedy of its consequences, but the conduct did not fall within the definition of terrorism. Yeah, fine. So you still have murder. And so, that loser that we saw in Fox, the big fat fuck. Why is there always the big fat fucks like Barnes and these other people? I mean, I know some fat fucks that I absolutely love, right? We have one of our friends. The Court of Appeals affirmed the appellate division's dismissal of the terrorism convictions and ordered a new trial on the remaining counts. The court noted that the statute did not define the phrase intent to intimidate, coerce a civilian population, but stated that it should be given its most natural and obvious meaning based on common sense and reasonableness in the context of the purpose and history of terrorism statutes. Civilian population could be read broadly to encompass a variety of communities depending on how area is defined and who lives within that territory. So it feels too ambiguous to me, and the judge feels like at this point he's reining things in, at least in this one. The court found it is unnecessary to precisely define the term civilian population, but it concluded that even if all Mexican Americans living in a particular area could be considered civilian population, the evidence did not demonstrate that the defendant committed his discrete act with the conscious objective of intimidating every Mexican American in the territory identified at trial. Gang members probably were the only ones. Moreover, the court found that there was no indication that the legislature enacted Article 490 with the intent to elevate gang-on-gang street violence to the status of terrorism, as that concept is commonly understood. The statute cannot be interpreted so broadly as to cover individuals or groups who are not normally viewed as terrorists. The court further stated that the legislature clearly did not intend to extend the reach of the statute to this type of crime, that it was apparent by looking at the examples of terrorism cited in the statute. The crimes committed by the defendant obviously were comparable in those terroristic acts. Okay, as Morales, page 107, we're about halfway there. As in Morales, the question presented here is whether the defendant's act, no matter how heinous, fits within the definition of terrorism, as set forth in the statute and as illuminated by legislative intent. The court does not believe the legislature intended the employees of a company, however large, to constitute a civilian population. You can see the problem here that the state was going to have on these things. And I would imagine a jury, especially a New York jury, the prosecution is just going to say, this is what it is. And they'll be like, sure, it sounds good to me. So now look, is this unique that the judge went ahead and dropped, basically reasoning, we're going over this, drops these 2 terrorism charges? Maybe he's helping the DA in a sense, right? You don't want to over prosecute, setting things up for appeal. Anyway, court does not believe the intent. Oh yeah, civilian population. It is clear that the term encompasses inhabitants of a particular area, or at least a group of inhabitants of a particular race or class living in the area. Okay, let's keep going on here. The court noted that the dictionary definition of population as the total number of inhabitants constituting a particular race, class, or group in a specified area. Okay, moreover, as in Morales, even if this court were to find the employees of one company to constitute a civilian population, there was no evidence presented that defendants' conscious, objective, or intent was to intimidate or coerce the employees of United Healthcare. The people point to defendant's journal entries found in his backpack as evidence of terrorist intent, but those writings ultimately do not aid the people's argument. The defendant's apparent objective, as he stated in the writing, was not to threaten, intimidate, or coerce, but rather to draw attention to what he perceived as the greed of the insurance industry, and as additional possible consequences to negatively affect the financials of the company. The defendant emphasized that could that be a terrorist act to financial terror? The defendant emphasized that he wished to spread a message and to win public support about everything wrong with the health system. The defendant explicitly contrasted himself with Ted Kaczynski, the Unabomber, because he indiscriminately mail-bombed innocents across the line. The terrorism, worst thing it can be. Exhibit A to the people's affirmation in response to defendant's omnibus motion. While defendant's own characterization of his conduct is, of course, not dispositive, where there is no other evidence of terroristic intent, the writings fail to supply that evidence, contrary to the people's characterization. The people presented sufficient evidence that the defendant murdered Brian Thompson in a premeditated and calculated execution. That does not mean, however, that the defendant did so with terroristic intent. Notably, the federal authorities, while recognizing Brian Thompson was gunned down in cold blood, did not charge the defendant with crimes of terror. Did they have terror statutes? I imagine they do, but with using a firearm to commit murder and related crimes, even though the federal terrorism statute served as a model for the state statute. Regarding defendant's intent, the acting United States Attorney for the Southern District stated that the defendant's goal was a grossly misguided attempt to broadcast views across the country. Was it? It was early in the morning. The defendant and director of the FBI stated that the assistant director of the FBI stated that the defendant committed murder to, quote, incite national debates. Well, according to Viva Frei, words are violence, and therefore, if he's inciting national debate, and words are violence, he's inciting violence, maybe that is terrorism. And that he deemed murder an, quote, appropriate recourse to satiate personal grievances. Okay, I'm going to skip down here. The court did not reach the issue of whether the state statute encompassed an act that only involved a single victim, but the court will note that the people's reliance on the 2 examples set forth in the statute, the Empire State shooting and the R.A. Halberstam killing on the Brooklyn Bridge, as incidents that encompassed only one victim, is misplaced. Those incidents were very different that they presented here. In 1997, shooting the Empire State Building, The gunman who expressed his desire for revenge in this treatment of Palestinians opened fire with a semi-automatic weapon on the observation deck, killing one person and wounding 6 others. In 1994, Ari Halberstam shooting the gunman motivated by a desire to retaliate against Jews. So wait, this guy's going against Jews. What was this one doing? Desire for revenge for the treatment of Palestinians. So, yeah, man, those Jews are causing problems. Fired shot after shot into a van of Orthodox Jewish students. Good Lord. Killing one and injuring 3 others. The defendant's targeting killing of... Okay, that's right. That's good. Let's read I'm sorry, I skipped over this. Here, the evidence presented failed to establish that the defendant committed the crime to coerce or intimidate a civilian population or to influence or affect the policy of a unit of government, and therefore the first 2 counts of the indictment are dismissed. The remaining counts of the indictment, including murder in the 2nd degree, are legally sufficient. Okay, let's talk about that real quick, which is, I think you can disagree with a judge, right? The prosecutors obviously thought that, and they argued that. It wasn't an open and shut case, okay? You can see when you walk through this. I mean, personally, I walk through this and I'm like, I'm not a fan of charging him with terrorism. This is something, I don't want to set any precedent, and it seemed a bit much. Plus, you don't have to. He's never going to see the light of day. Plus, New York doesn't have a death penalty, okay? So they're not going to put him to death. So what are you just going to keep adding more years, more time? He's going to be put away, okay? I mean, I think his diary is kind of like self-incrimination here. So he's going to be put away. You don't have to have these enhancement statutes. Plus, they don't do what you want to do. I think they're dangerous, actually. Correct. Tyler broke up Tower Gang to drive us to his bicycle channel. Well, very sinister stuff. It is true. Address the allegations, Tyler.
That is a career-ending slur. It is a career.
Yeah, it's a career-ending slur. How dare you say that? It wasn't even the good biking, like all the Red Bull. It's one where they pedal a ton and never do any jumps. Not true. They jumped a little bit. The gayest of all biking. Yeah, the tour of, by the way, we just had the tour of Spain called the Vuelta a España. Maybe you've seen stuff about that. I talked a little bit about it when I had, I think it was Jose in here. Yeah. And they did protests over there. There's a cycling team called Israel Premier Tech, okay? It used to be called Israel Cycling Academy. And so they push back a lot. There's separatist movements in Spain, if you didn't know. And this year in Spain, they were almost all in the north. That's in the Basque country. That's the big part of their separatist stuff. It was all up there. Usually it's all around the country, but this time they just kept the race up in that part. And they had protests, and they had to stop some races and do this stuff. They were protesting because this team, Israel Premier Tech, is in the race. And I've been, guy on the red carpet the other night was talking about it. Max Blumenthal's tweeting about it, some things about, the Palestinians. Personally, me, I'm not a friend of the Zionists, but I was fed up with it. It's like, you're not seeing them going and shutting down, because when you get out on the road, one, it's dangerous. They're jumping on, some guys wrecked. It was some bad crashes because of this stuff. It was ugly, and it's not safe, right? But you're using the roads, okay? And so you're not seeing them out there protesting and ruining soccer games, right? Why don't you go do that? Who cares about bike racing? Go ruin a soccer game, okay? But it should be noted, what's interesting about that team is they aren't sponsored by the country of Israel. The owner is an Israeli, okay? Or he's a Canadian Zionist, is a Jew. And he wanted to pump the state of Israel, so he included them on the name of the jersey as a sponsor, just because he wants positive stuff about them. Oh, whoops. Yeah. So it's a bit interesting because, you have other teams that race out there. There's a team from the UAE, a team from Bahrain, Jalula or Alula. So there's some of these other national governments that are not so great either. Okay, so let's see here. Defendants claim double jeopardy violation and request to stay. Defendant argues that the concurrent state and federal prosecutions violate the double jeopardy clause of the United States Constitution, barring prosecution for 2 offenses based upon the same act or criminal transaction. However, as the United States Supreme Court has held, there are 2 sovereigns. There are 2 laws and 2 offenses. Basically, can you be convicted in one state and then another state for the same crime? Possibly. Looks like you can. However, there are two. Okay, Gamble v. United States. A crime against two sovereigns constitutes two offenses, such as each sovereign has an interest to vindicate. Thus, there is no double jeopardy violation. While it is true, CPL section 420 spot 20 grants greater protection than that of the state or federal constitution, that bar is triggered only when a prior prosecution ends in a conviction by a guilty plea or once a jury has been sworn. Therefore, because neither event has occurred, defendant's motion is premature. Yeah. Maybe it's going to be double jeopardy, but let's wait until you get at least jeopardy. Defendant nevertheless that he is privileged by concurrent proceedings because he will be forced to litigate a federal case in which he faces the death penalty. There you go. So once again, we don't care that murder one is off the table here for this case. One, they don't have the death penalty even, so you're going to get it on the federal side, so don't worry. What do we got there? During federal trial, thus implicating his rights to defend himself and against self-incrimination. Defendant suggests that the federal case should proceed first, even though the federal and state authorities have agreed that the state case should proceed to trial first. The court is not persuaded that proceeding to trial in the state case first will cause the defendant severe prejudice, and the defendant's claim that any state trial testimony will prejudice his federal trial is merely speculative. Moreover, defendant cites no case law or authority that would permit such a protracted adjournments, as even a defendant concedes that the federal case will take several years before trial. The court is also confident that counsel will have the capability to manage an approximately 2-month state trial during the pendency of the several years before the federal case proceeds to trial. Defendant's request to stay the proceedings is denied. Summary: counts 1, 2, charging defendant with murder in the first degree and the furtherance of act of terrorism, and the murder in the second degree as a crime of terrorism are dismissed as legally insufficient. People presented legally sufficient evidence on all other counts, including murder in the second degree intentional. Thus, the motion to dismiss is denied in all other respects, and this motion to stay the proceedings. Okay, if this guy was such a, maybe we need to go back here and find that stupid comment. There we go. Now you've read it. If the judge was a complete hack, he would have dismissed, maybe would have stayed this. We would have stayed this to being done after the federal case, and then we'd be putting it off for years, okay? He wouldn't have granted suppression hearing. He would have dismissed it all entirely, okay? So let's see what this guy had to say again. Now you've known all that. Let's go back.
New York has a screwy situation when it comes to their statutes. You know, most states, premeditated murder means first degree, means potential life sentence. In New York, first degree murder requires an aggravated circumstance, like you killed multiple victims, or you killed somebody in the course of an escape, or that it was terroristic. And that was really the only category that might fit here. The judge looked at it and said, tell me your evidence, let me hear why it's...
The only category that might fit here. You have, well, okay, I get it, what he's saying about multiple people.
And that was really the only category that murder requires an aggravated circumstance, like you killed multiple victims, or you killed somebody in the course of an escape, or that it was terroristic. And that was really the only category that might fit here. The judge looked at it and said, tell me your evidence, let me hear why it's terrorism. But terrorism means specifically coercing the government or coercing the general public to do something. And they said, this is ideological, this is premeditated, this is targeted, but not terroristic. And notice the DA's office basically said, we hear you, didn't say anything about trying to appeal it or fight it. So they knew they were out on a limb. Now it's gone. And I think it's a real serious blow to that case. It was never a death penalty case on the state side, but now you're talking about ratcheting it down to a second-degree murder. And again, blame the New York kind of progressive system a little bit for this problem.
I'm blown away. We just read through there what the terroristic statute enhancement. You still have second degree intent and multiple other. I'm not sure why is this any different than the guy that cut the girl's throat? Was that in New York? I don't know. Daniel Penny, right? The guy died. They tried to. I don't think that was second degree though, and maybe it was. Maybe they said it was intentional on that one too. It's crazy if you can't figure out that A equals B over the two things, right? They mean something else. It's like speaking two languages, or understanding when you go to a different country that, the word go might mean something else. You pronounce it something else. It means the same thing. You just say it a different way. This guy can't wrap his head around that. Doesn't make sense to me. And that's a little disturbing. Okay, so I think we're good there. Second degree, we're gonna be fine. Let's take a look here at, I'm not gonna play all of this, but here's a little bit of our boy Tyler in court.
403576, State of Utah versus Tyler James Robinson. Could you state your name?
Tyler James Robinson.
Thank you for being here, Mr. Robinson. I'm Judge Graff.
Hi, Judge.
Mr. Scortis.
Good afternoon, Your Honor. You're probably already aware of my presence or why I'm here, but if not, I am not entering an appearance. I'm not counsel on this case. I'm working with the county to get counsel assigned, but we need you to allow for the appointment of counsel.
Thank you, Mr. Scortis. I want to go through the qualifications for indigency, but that is my intent, Mr. Scortis.
Very well.
And I thank you for being here.
Indigent. Okay, so they're saying basically he can't afford an attorney, so one will be appointed for him. I have this. Let's go here. Murder in the second degree. Here it is. With the intent to cause death to another person, he causes the defendant acted. Oh, these are defenses. Let's go. I wanted to see. Let's see Article 125. Homicide and related. I think it was 125 point. Aggravated murder. Murder in the first degree. There you go. Person is guilty of murder in the first degree with the intent to cause death. He causes the death of such a person, and I think it's VII, which would be what? 8, right? As part of the same criminal transaction, the defendant was intent to cause physical injury or death to additional persons, cause additional persons other than the particular criminal transaction. So you can see here, there's all these different enhancements in the course of committing a murder or further into robbery. So that's like felony murder type of stuff. Okay. We're done with that. We're done with these guys getting excited about Luigi as well. Charlie Kirk killed. Tyler Robinson is the one. Let's look at the charging document. How many pages? We got 10 pages on this. I'm not going to go through all of it because I think some of it is we're just going to get. Let's take a look. Aggravated. By the way, this is a state case, which is important. It's not federal. I say it's important because we are. Oh wait. Oh, they are calling for Tyler's death now. I had a video last time and I took it off. I swapped it out for this one.
To my friend Charlie Kirk. Rest now, brother. We have the watch, and I'll see you in Valhalla.
That is so well done. I love AI at times. State court. Why is that important that this is in state court? Because if it goes to trial, we're going to get video, right? Count 1, aggravated murder, capital felony, a violation of Utah code, and that September 10, Utah County, the defendant Tyler James Robinson intentionally or knowingly caused the death of Charlie Kirk under the following circumstances. The defendant knowingly created a great risk of death to another individual other than Charlie Kirk, and the defendant conviction of this offense may carry the death penalty. Okay. Victim targeting enhancement in violation of the Utah code, Tyler James Robinson intentionally selected Charlie Kirk because of Tyler James Robinson's belief or perception regarding Charlie Kirk's political expression. If the trier of fact finds beyond a reasonable doubt that the victim targeting enhancement applies, the sentencing judge or the board of paroles or the and parole shall consider the defendant's selection of the victim as an aggravating factor. Violent offense committed in the presence of a child. Aggravating factor, the sentencing judge or the board of pardons and paroles may consider as an aggravating factor in their deliberations that the defendant committed a violent criminal offense in the presence of a child. Yeah, okay. Discharge, count 2, discharge. So those are enhancements to the first one. felony discharge of a firearm causing seriously bodily injury. I'm not going to read through the definitions of each one of these, but you can kind of get it from the title. Enhancements to those, even out there in Colorado. In the presence of a child, victim targeting, okay? Count 3, obstruction of justice. It's a second-degree felony in violation. I mean, how's he going to serve these other ones if they put him to death, though? I'm kidding. Tyler James Robinson with the intent to hinder, delay, or prevent the investigation, apprehension, prosecution, basically because he didn't turn himself in right away, I guess, and he hid the gun. Second degree felony, obstruction of justice in violation of Utah, the defendant with intent to hinder, delay, or prevent the investigation, apprehension, prosecution, okay. Tampering with a witness. Let's see, defendant believed that official proceeding or investigation was pending or about to be instituted, intended to prevent an official proceeding or an investigation, attempted to undo or otherwise cause his roommate to withhold testimony, information, okay, yeah. We'll see. They're going to have to prove all this. And by the way, they have this, and then they're going to have to put some things in the charging document just so you can get an idea of the judge do we even proceed to a preliminary hearing, okay? Or do we just say, you're full of crap and we're going to go? So the standard here is not high, and you don't have to have a full, robust exhibits like I talked about before. Okay, we've seen this with Nick, and then there's whether you're going to hold him out. They're just trying Nick Rekieta, whether they're just going to get him an attorney and move on from there. So tampering with a witness, telling his roommate to do something, I guess, destroy the messages. Tampering with a witness, violent offense committed in the presence of a child. Targeting enhancement, probable cause statement. So here we go. Here's the probable cause statement. Brian Davis of the Utah State Bureau of Investigations, having probable cause to believe that the defendant committed the above listed offenses, submitted the following evidence in support of filing of this information. So once again, it's probable cause standard. We've been through this with Nick Quente. I saw someone online going, oh my God, I don't know if it's a DA. He's out there reading those text messages. That's a complete violation. It's like, no, it's in the document. And then there's Candace, which is she's freaking out about the sequence. And I get it. Please, just back up a bit. Just give us more. I appreciate, and I want her to document all this stuff so that when the time comes, if they can't prove the things they're doing, then we've got problems, okay? Which is fine. So they need to be spitting stuff out more and more. So they give us timeline here of when he was shot. I want to kind of get to the shooting, turning points, nonprofit, the event. I'm not going to read all this here. Surveillance investigation. At the moment of the shot, UVA police officer was watching the crowd from an elevated vantage point, but not elevated enough to see the shooter. As soon as he heard the shot, he began to scan the area for threats. Believing the shot came from a rifle because of its sound, he looked for potential sniper positions. He noted a roof approximately 160 yards away from Mr. Kirk as a potential shooting position and rushed there to look for evidence. I mean, none of this happens before when you're like, we just had Trump or Butler, right? All this stuff about we had counter snipers up there and all this good stuff. And no one's doing, I guess, that. I don't know. Do you expect this to happen to Charlie Kirk? Maybe not. I mean, he did say he was being threatened by Israel. The suspected shooting position is adjacent to an open, publicly accessible walkway. To access the suspected location, a person must climb over a railing and then drop to the roof only to slightly below. The UVA officer climbed over the railing, down onto the roof, and then walked to the suspected shooting position and confirmed a clear shooting corridor between the position and Mr. Kirk's seat. He also noticed markings on the gravel rooftop consistent with a sniper having laid on the roof, impressions in the gravel, potentially left by elbows, knees, feet, person in a prone shooting position. Police reviewed surveillance from the camera covering the roof and discovered that it recorded an individual dressed in dark clothing across the railing from the public walkway and drop onto the roof at approximately 12:15 p.m. Although the individual moved out of camera's view for a short time, no, I'm just kidding. The camera captured the individual running across the roof and then low crawling the area. The UVA officer recognized as where the suspect sniper had dropped into the prone shooting position. After a short time, which matches the known time of the shot, the individual arose and ran across the roof to the northeast. I mean, I'm open for all this surveillance that we're going to see. The discovery led to the intensive review of UVA surveillance recordings to attempt to track and identify the suspect. Surveillance revealed the following. At approximately 11:51 a.m., the suspect entered campus from the north. He had been wearing a black t-shirt, an American flag in its center, a dark baseball cap. I'm hoping, we saw steals. I'm hoping we're going to get all this video. Throughout the surveillance, the suspect keeps his head down and rarely raises his head enough to get a clear image of his face. As he proceeds across the campus, he is seen walking with an unusual gait. All this reading's getting my throat. We might be able to have to shut it down here. I think I am. Okay, so let's go to each rifle contained etched inscriptions. And by the way, they're not showing them. They're just listening. This is just a probable cause affidavit. Okay, ban Photoshop. I mentioned earlier. I said I mentioned you. What to stream? Drinking food, seltzer water. But man, that sounds good. Voodoo Ranger. Probably because I'm gonna either do a bike ride here. Let's see, 6:15, 6:18, or maybe go to the gym and then I'll drink something. But Voodoo Ranger, I need to get some more of that. So once again, this is just listing everything out. So people are like breaking this down as if we just saw the Zapruder film or we just saw the full, evidence presented. This is not. This is just probable cause. You just got to list some things, but then you have to prove it at some other point, right? Probable cause is just, we can even, what is probable cause? Okay, well, what's AI say here? Probable cause is a legal standard that requires law enforcement to have reasonable grounds to believe that a person is committing, or will commit a crime. Okay, so it's so minimal. It's not even much. These are the cartridges. Okay, whatever. He wrote on the cartridge. The rifle ammunition rounds and towels were sent for forensic processing. DNA consistent. Okay, so they got his gun. If he's not, patsies, or all this stuff. So they did the DNA. They say it goes to him. Law enforcement was unable to immediately locate the shooter, so they published photos. His family found him. I want to go to the roommate. The police interviewed Robinson's roommate, a biological male. That's important to put. This is probable cause affidavit. You want facts in here. A biological male who was involved with a romantic relationship with Robinson. The roommate told police that the roommate received messages. And I believe this. This is what's fascinating. Candace Owens is claiming, for whatever you want, that the roommate's family is reaching out to her saying, hey, this roommate, he's not necessarily a good guy. That's fascinating. We got two situations. One, the shooter, alleged, suspected shooter's family turns him in. The twink, his family's got problems with him as well. And then you get people out there. Who was it? Montel Williams is saying, this is like a love story. This guy's killing people for his lover. Isn't that amazing? And it's just like, what? Okay. So, first of all, it just says roommate. That's what they're doing. They're trying to hide his thing for a little bit. These are supposed to be text messages back and forth. Once again, I'm not doing anything other than seeing these, assuming that they are going to have to produce them at some point, and they're going to have to produce them outright. Now, this is, there's a lot of things that people are out there saying, hey, this doesn't sound like how someone would talk. I get it. A kid that age. This was a somewhat, someone's also said, oh, he's very clean and he's going to, I saw some mom out there and she's like, my teenagers would never talk like this in text. And I'm like, okay, I get it. But I have 4, well, they're not, there's only one of them is a teenager now. Sometimes you get hooked into voice to text and it corrects everything for you. Maybe that's it. I'm pretty anal and I'm doing commas and periods. Okay, so that's an adult. I get it. But I'm also was an engineer and I had trouble always. I had to do those kind of things. This kid was an engineer, very smart. Maybe, the fact that he used the word vehicle is because he's smarter than that one chick online. Like, my kids would never, and I'm like, maybe you have dumb kids. I don't know. Smart kids, maybe they like to be like that. Maybe, I don't know. I don't know. I'm just saying. Why are there no timestamps? Great question, because you don't have to. This is a probable cause document. You don't need timestamps for this. They're just wanting probable cause. They're just saying this is what took place. They don't have to prove this now. At some point, when this is just to say we're going to hold him over and there's probable cause to actually charge him, maybe these aren't quite right. Perhaps, right? By the way, do you think it said roommate? No. So not everything is verbatim here. This is hearsay. First of all, this document, you can't put something like this in there. So we don't care about timestamps. All they have to show, and they don't have to show the completeness. This isn't, once again, a document. You got to have authentication. You've got to have completeness. All these different things against hearsay. This is not that. This is just saying we have probable cause. What is it? We believe a crime may have been committed or has been committed. Charlie's dead. So we know a crime was committed. And we think this guy may have done it. Well, we have evidence that says that he did it. Okay. And here's some of the evidence that is, right? People have Karen Reed, right? Similar stuff. I mean, all kinds of crimes. They do this. They don't always get convicted because sometimes it's not true or it's out of context, right? You could be joking and right. Maybe there's more context in this. And we saw this with the last case we just did, which is that wasn't terrorism acts. He had a book that said exactly, basically defended him to that. And the prosecution is going out there and saying it is the case. So once again, this is why I'm just saying, ease your horses. Let's calm down a bit. We're just saying, okay, you're going to, I don't even know how to, I don't know, anything here. It's just probable cause that something may have happened and that we're going to, okay. I'm still okay, my love, but I'm stuck in Orem for a little while longer. Shouldn't be long until I come home, but I got to grab my rifle still. To be honest, I hope to keep this a secret till I died of old age. I am sorry to involve you. And why are you? See, by the way, these don't necessarily, the way they do this, it make you think, oh, this went straight here. This is this stuff. There could be, look at these little ellipses here. Okay. I think the point here is there's other stuff in between that may have nothing to do with it, or it's time, or I don't know. You weren't the one who did it, right? 4 question marks. I am. I'm sorry. I thought they caught the person. No, they grabbed some crazy old dude. And see, some of this, we're gonna have to. Once again, we're gonna have to. I'm not gonna walk through all this. I'm not gonna walk through it. So they have text messages that basically sound like he claims he did it. Once again, talking about the scope, and people are talking about the gun. I did see some guys saying, look, this gun, when your guy jumps off the roof, at some point he does go and pick something up, and it's hard to tell. Maybe he drops the gun. Maybe that's where the scope gets whacked out there. I don't know. We're going to have to see a lot more. And this is just, once again, just an indictment here. Search of his residence. Police have search warrant. During that search, police discovered a shell casing with etchings like the etchings found in the shells of the rifle near the UVU. Police also found several targets with bullet holes in Robinson's home. Aggravated murder pertains to Robinson's shooting and killing of Charlie Kirk in a manner that exposed others, in addition to Mr. Kirk, to great risk of death. Felony discharge of a firearm. Okay, talks about the counts here. Yeah, so there you go. Both guilty, send him to the gallows. Yeah, whatever. It will be interesting. It will be interesting. So here's part of my deal too. He's going to get some sort of defense attorney, okay? He's not going to get a piece of shit. Well, he may, but even if that guy is a POS, there's going to be people out there like Mangione's fans, whatnot, maybe a lot of the lefties who are going to want to support him, and for whatever reason. Maybe it's just to be in, whatever. He's going to get money. He's going to be able to put up a defense. And those defense attorneys are going to do some work. And some of that, I would imagine, is being able to do extractions from the phones, right? There's so many things I would do immediately when people are freaking out. I'm like, okay, I actually want to see all this. One, I would like to hear him talk. I would like to hear this roommate, because how are they going to, here you go. Okay. A few things, evidence-wise. The actual text messages, they're going to have someone come in. They could do a policeman come in and read the text messages to get him in there. Now, this is all hearsay, but there's an exception to hearsay. They could either have the roommate come in and read this stuff, and they might call him to do so, right? I don't know why you're going to give him a pass, make him testify. But it's the exception is admission of a party opponent. So if he's saying things and it's his statements, he's the party opponent to the state. So when the state brings their case, they can have this admitted, even though it's hearsay. He doesn't have a party opponent, so he can't do that on that same other side. But yeah, there you go. Do I have any other things here? Here's some other lawsuits I was going to talk about. Kash Patel's girlfriend has sued. Let's take a look. We'll do this at another time. She has sued Kyle Seraphin for defamation. Okay, maybe we'll look at that next week. It depends on what the other legal standard stuff is going on. There is this. What is this one? Oh, that's more of the same. Something to do with pickleball. Pickleball. New Jersey town drops plan to condemn a church to build a park and pickleball courts. Okay, I played pickleball this morning. And what's this one say about deepfakes? California law restricting materially deceptive election-related deepfakes violates First Amendment. Maybe it does. Maybe it doesn't. Should they allow Mossad agents to sue people? Evidently they are. Okay, what did we learn today? Okay, we learned this.
And it's not going to be a question of Viva's anti-free speech. No. Cheering for the murder of your political adversaries and murdering your political adversaries is domestic terrorism.
Okay, so he is against free speech. And some douche in there said, yeah. Okay. I saw Joe kind of going, nah. And Nate wasn't like buying it. And potentially criminal Sean didn't even chime in that one. So just throwing that out there. I don't know about that. What else did we learn?
That is a career-ending slur.
Okay, the bitch there. We also learned that free speech, hate speech is not a thing. Okay, you can do that. But I just want you to understand, when you have people like Pam Bondi and then Trump comes out and he's supporting her, and then you have Viva Frei saying stuff like that, but then also going online acting like there's frauds out there all over the place. And they can't stand, even Viva, he says that, he tweets that, and then he goes the other way and tries to say it's, hate speech. He can't keep his facts straight because he has no core, right? His guiding principle is what do I do to grift off of this, the right wing? And maybe he believes that, but it's like whatever this flow, he can't go against the grain. It's all just pushing him down. It's just gravy that flows into Barnes' mouth, and he's just getting slept along with it. So, you got disturbing people like that. So that's one other thing we learned here. We learned that Luigi is still getting charged with as much murder as he can, and that you got to watch out for people on both sides trying to capitalize on things, just like the Charlie Kirk thing. There's people going here and there's people going there. They're all trying to say what Charlie Kirk believes, and there's a lot of videos out there. Even our buddy Jose, he was trying to break this down, which I think at this point it's perfectly fine. If you want to talk about the legacy and whatnot, let's talk about it. Perfectly fine. I don't really care to engage in that because it's what it is. It's like, guy's dead. I'm not going to really do that, but I don't have a problem with that at this point. Okay. I did between the shooting and the announcement of his death. That probably wasn't the time to go after that. Okay. So Friday we'll be back for a Friday show, and I think I'm out of here. I'm going to go maybe the gym, maybe some Voodoo Ranger. I don't know. Thanks everybody for coming in. We will see you until next time. This is our like us, subscribe. I'm also trying to stream this out on Substack. We're gonna do some private stuff coming up soon. Bye. Outro. Salute.
Stripes and bright stars. Never mind.